Hi, everybody. Thanks for joining us today for our webinar analyzing the Colorado Privacy Act final rules. My name is Dave Stouse. I will be your host today for our webinar. Sadly, you are stuck with me, nobody else today. Lots going on, so we just wanted to have it just be a solo endeavor today, but we'll try to keep it lively for you all so we don't get anybody falling asleep at the wheel. Before we start, if you are so inclined, that QR code will take you to my LinkedIn profile. If this is something that you're interested in, encourage you to friend or follow and can, keep up to date not only with Colorado, but with just few little things happening around the country, like the My Health, My Data Act and bills being proposed in other states. Okay. If you've attended a previous webinar, I think you know that I like to start the webinars out with a roadmap. This helps you guys understand where we're going to go and helps me remember where I'm going to go as well. But hopefully this can kind of head off, if you have questions, it can kind of head those off as you might see one of the topics that we're going to address down later in the program today. I will say, there's typical housekeeping stuff that we like to talk about at the beginning. That is, there's CLE being offered for this. I don't know much about the CLE that's being offered. What I do know is it's being offered. I understand they tell me that there's a box you can check or a button you can check at the bottom of the screen to get a CLE certificate. If you have any questions, you can feel free to email me. I usually get somebody else involved, but always happy to help out however we can. If you do have questions about anything, feel free to ask them. I am flying solo, as you can see, so it's pretty tough to read questions and answer them at the same time as I'm presenting. But if we have some time at the end, I'm not quite sure that we will. I can try to answer some questions, but hopefully we address a lot of what you have along the way. Okay. As you can tell from the topics as well, we are going to cover a lot today. There's a lot in the rules. The rules are, 44 pages long. I think the statute itself is 30-something pages long. So there's a lot going on in the rules. As you might suspect, you might already know as much. We're going to move quickly is the point of the story, is we're going to move quickly and try to address a lot. But hopefully when you come away from this, you have an understanding of, the different pieces that are in play here. Maybe not every single nuance involved, but pieces. Okay. Let's start with some takeaways. Then if you, learn nothing else from today, then perhaps you learn these. First, we have sorry about that. So effective date is the same as the statute. This is not like a CPRA situation where we've got like these random dates going on. I mean, the CPA goes into effect on July 1st, and the regulations go into effect July 1st as well. I will say, credit to the Attorney General's office in Colorado for getting these done. They're done, they're finished. It's April. We have time to comply. Maybe not as much time as people would like, but they did actually meet their goals of getting, significant rulemaking done in a timely, effective manner. And so it's not an easy task, as anybody who's engaged in that type of process knows. What I'll also say, number two is, if the last time you visited with us was the draft rules, and you attended that webinar, or you've been on the blog and seen all the writing on the rules, understand that they started high and came down for the most part, right? There are still concepts, and we'll talk about number three in a second, that are significant with Colorado and unique, but by and large, the initial draft rules set a ceiling and then negotiated down on a lot of provisions. And in that regard, made them more pro-business, which I think is certainly helpful to our client base in many regards. That said, number three needs to be pointed out, which is, the Colorado rules go further than California and certainly, some other state statutes in some significant respects. The sensitive data inferences, we'll get into those in a little bit. That's really a creature of the regulations. The privacy notice provisions are much more than what's in the statute. They walk those back some, but there's still really some important nuance there that you're going to want to think about when you're drafting. Secondary uses, data minimization, processing purposes, those are all the 600 rules, right? And those are significant, right? And they really kind of work together in my mind with the California Regulation 7002, because you have to look at, all of this. Certainly if you're a 5-stater or like a 6-stater now, and we're adding, you're going to have to look at how all this comes together. Data protection assessments as well, just, really significant in what they did here in the rules. the additional information they're going to require you to analyze that's well beyond what the statute says you need to analyze. They really fleshed that out. And the profiling stuff as well got really fleshed out as well. We're going to go through each and every topic of it, so don't think, I'm shorting you on the details here, but I do want to basically give you that, at the beginning, these are the things that we're really talking with clients about discussion. Okay, quick recap of the CPA. I am not going to explain the entire Colorado Privacy Act to you. What I am going to explain, though, is scope. Everybody always asks the same question when they show up on the webinar. Did they change the scope in the rules? No, the scope is the scope. They did not create any new differences in the scope of who it applies to. That stayed the same, right? So if you were not subject to it the day it passed, you're still not subject to it, right? And vice versa. So scope here, and I think you guys are familiar with the thresholds now. I mean, it's all the same as we see these Washington Privacy Act variants come out. It is, you're doing business in the state, essentially, controller process, PI, targeting Colorado residents with commercial products or services, and they define that term in the rules too if you're looking for a definition. And then we have this 100,000 threshold, right? It's 100,000 consumers, controller process the personal data for 100,000 consumers in a B2C context. It's not B2B. California went B2B, an employee. That's not the case in Colorado. That remains the same with respect to the definition of consumer. This 100,000, I mean, it's really kind of interesting as we've seen this play out in other states, right? So we have states like Connecticut that passed it, and they've got 3 million state residents versus Colorado that's got close to 6. So their 100,000 really becomes significant. Montana's close on passing a bill right now, and they are using 50,000, primarily around the idea of around percentages, right? And they've got like 1.1 million. So that would even be like a 4.5% of the state population. So anyway, that has significance, 100,000 does, but also the OR one below as well, which is the sell plus 25%. That's very unique in Colorado. What basically is if you're deriving any revenue from the sale or receiving a discount from sale or goods and services in the 25,000. So really need to think that one through because, most other states say things like derive 50% or 25% of your revenue from the sale of goods or services or discounts plus the 25,000. Colorado, it's any, and that can really be a sneaky way in which the bill kind of trips you up. Exemptions are the exemptions. These are fairly typical, right? We have our GLBA exemption, no straight up HIPAA exemption, but there's a ton of PHI-like exemptions in place. I'm guessing you know these. I'm not going to really spend much time on these right now, other than just to kind of note that they're out there. And then, sort of the the threshold issue of like the obligations, right? We're going to dig into these, but I wanted to give you a slide that you can kind of use as a reference point. We were typical structure of rights, right? Access, delete, port, correct, confirm, processing. There is not a right to revoke consent in the CPA. That was something that got brought in by Connecticut later. But in the rules, they backfilled in a right to revoke consent because that goes into the third bullet point, which is sensitive data, which is you must obtain consent. And now the rules have backfilled and say you have the right to revoke that consent, right? You have to put a privacy policy out. You have to do your data protection assessments. We'll talk a lot about those. Data processing agreements is also like one of these foundational issues that's in the statute. But spoiler alert, they do not address data processing agreements in the rules, right? Very fortunate in that regard. We know that in California, in the rules in California, they did address the contractual requirements of data processing agreements that need to be in place for service providers, contractors, third parties. Colorado did not do that in rulemaking. So you're done. You can look at the California regs. You can look at the statutory requirements in Connecticut. I would encourage you look at Connecticut and Colorado, which those two match up in substance, and then look at California. And if you got those, I think you got everybody as far as these data processing agreements go. Okay, so sometimes it's important to point out what is not covered as much as what is covered. Listen, that was brief. I mean, that was like CPA in a minute. If you want more resources, there's QR code. We have a CPA resource center. It's a cure for insomnia. I tell people, right, you can get on there and really do some deep dives on our blog posts, how the rules developed, all that type of fun stuff. Okay, so let's dig into the rules. Now we've done our big wind up. Told you before, consumer requests in the previous slide. We talked about access, correct inaccuracies, delete, port, confirm if the controller is processing. So there's like your core rights, right? Now we've got our opt-out rights, right? So that's opting out of target advertising, sale of personal data, and profiling, right? So let's just kind of frame that as we dig into this subject. Starting from the beginning, right? Let's just kind of go through the process flow here. Receiving requests, you're going to have to, and this is going to feel, just give you a front, right? It's going to feel a lot like California, right? If you're familiar with California, you're going to be in a good shape here, but I don't suppose everybody is subject to California. Some people out there are going to be subject just to Colorado. So to give you the flow, right, you're going to have these methods of receiving requests. Like, how do I ingest consumer requests? All these rights I just talked about. Well, you're going to have the methods are going to be in your privacy notice. That makes complete sense. You're going to have, very long and lengthy and detailed and lawyered up privacy notices. That's life right now with these statutes. And then you're going to have two designated methods, unless the exception applies there. So for normal businesses that have brick and mortar, telephone orders, those types of things, you're going to have two methods. And if you have a website, then it's going to be through like a digital interface, such as a web form, right? Now, if you are only online, if you are exclusively online, that's all you do is online, then you can just use an email address, right? Tell me like, well, Dave, I know this already. It sounds like California. Yes, this is California, right? They have not strayed away from the California structure. Good to hear that they haven't. There's also nothing when we talk about this web form here, there's nothing that says you can't blend requests with other states. California in particular, but also the other state laws, right? So you can be gearing yourself to use web forms to receive these requests and checking the box in multiple states, right? It's very helpful. And I know we've been talking with clients even before it was required. We were talking with clients about using web forms is really a really good way of regulating the way in which you handle requests that come in the door, because inevitably you get a request that says, my name is Joe, and I would like to access my data, right? And you don't have enough to be able to actually respond to that request. So using web forms has been also always advisable, but now you're seeing it firm up as required. But again, you can do interoperability here across states. Colorado did a really nice job of doing that. And then we've got the in-person ones as well. That just makes sense, right? If somebody shows up at your brick and mortar store and they want to exercise their request, then you've got to have an in-person method to do so. The rules get into what those in-person methods could be. I will not get into them, but you can dig in there. I should say as well is, there's substance around this, right? So like it has to be easy for consumers. You have to take into account like how consumers deal with you, those types of things, right? There is not a requirement to have a 1-800 number. That is still a creature of only California, but you could use a 1-800 number. If you have to use it for California, you could use it for Colorado, right? But you may have to change the way in which you address training or your voicemail, those types of things. There's also, I don't have a slide on it, but it's worth noting, there is also a regulation 611, 6.11 that gets into documenting requests. Sounds just like California. So if you have a request come in the door, you have to document that you received it and then how you've responded to it, including your denial, those types of things, right? Familiar construct here, but you're basically going to be using your existing privacy structure and program to jump off. Okay. Again, I went through a bunch of these things before, right? It doesn't have to be Colorado specific, as long as it's doing what it needs to do with respect to Colorado. Gives people a clear understanding of their rights and otherwise complies with the regulations. And again, familiar concept on accounts. Can't require consumers to create an account to effectuate a consumer request, but you could, if they have one already, you can use that to effectuate that request. Response timing. One way in which it differs from California is there is no 10-day notification requirement, right? So if you're doing with California, if a request comes in within 10 days, you got to provide a response, and that response has to say, the general construct of how you're going to verify the request and how you're going to respond to the request, right? That's not in Colorado. But flip side is it's not prohibited by Colorado, right? There's nothing that says you can't do it, right? And so I think for clients, we talk about like, how do we get interoperability? The concept here would be, you could provide for, these other states that are not California, you could use that 10-day request to do things like your verification and authentication process and have good interoperability there. As far as timing goes, this familiar concept of 45 days is unchanged from the statute. It's interesting in the opt-out request, right, is, the time frame in the statute is the 45 days. But here it says, has additional language in the rules of saying like as soon as feasibly possible and without undue delay. There's a slight tension. I think there's a slight tension there between the time frame. But, for a lot of these requests, like the opt-out of sales and targeted advertising, they're really going to be instantaneous, right? And then profiling probably as well, because it has to be done at the point of profiling. So maybe operationally not going to be the biggest issue, although we always find as privacy lawyers that there are many, many use cases out there. And a lot of nuance there, but just understand there's that slight distinction. And also, too, worth pointing out that in the draft rules, there was talk about the opt-out request having to be processed within 15 days. That's, you might be thinking, well, that sounds a lot like California. Right. They were trying to match California in the draft rules. 15 days is gone for the opt-out request. And now it's this, as soon as feasibly possible, backstop by this 45 days. Denial, the right box. Hey, you're allowed to deny requests. You don't have to do every single one. If there's an exemption that applies, and you can deny, but you have to tell people stuff, right? So if you go about denying a request, you're going to have to tell them why you've done it. That makes sense. The rules list a few factors there, like if it's a conflict with federal or state law, if you're relying upon an exemption, you have to describe the exemption. If you can't authenticate somebody, you have to tell them why you couldn't authenticate them. If you have a good faith basis for denying the request, you have to tell them what that good faith basis is, right? I think what this just comes down to is, you're going to be more descriptive in your response procedures with respect to why it is that you're denying the request, right? And I know we have a lot of form documents that we use with clients on responding to requests. And you just got to make sure that those you run your existing ones or your new ones through the statute and the regulations to make sure that you're actually checking the boxes of why it is that you've properly denied the request. And then this appeal issue. So this is unique in the Washington Privacy Act variants, right? Where if you're going to deny a request and you have this ability, you have to tell people they have the ability to appeal that. And so that's not in California, but we see it in these statutes. And you have to go through that process, and you have to establish a process for appealing. In your privacy notice, you have to provide the methods for appeal. Okay, a lot on that, but we can move on to authentication. Again, to draw the comparison with California, because I think it's good for frame of reference. If you look at the California rules, I'm sure you have. It says things like, you need to verify 2 or 3 data elements depending upon the sensitivity of the data, right? And have people sign a declaration, all those types of things. You will not find that in the Colorado rules. Colorodo's rules do not have prescriptive requirements for how you would authenticate a request, right? Instead, what they talk about is to be using commercially reasonable methods. What I do want to say, though, and I want to kind of point this out because it is important, at least to privacy lawyers, it's important. Colorado requires authentication of not only your typical request, access, correct, delete, port. It also requires a level of authentication for your opt-out requests, right? This is different than California, and this is different than Connecticut, right? So it's something to think about here, which is if somebody comes to you and says, I want to opt out of sales of my personal data, or I want to opt out of targeted advertising, the rules allow, they don't say you have to, but they allow authentication of that request. Prove to me who you are. To touch interesting to kind of think about, because it's not in California. Maybe if somebody wants to opt out of targeted advertising, like don't track me across the internet, this concept of like we have to prove who you are first can be potentially viewed as a barrier to effectuating that request, depending on your point of view. But anyway, it's just worth pointing out Colorado and Virginia, for that matter as well, require authentication. Connecticut and California do not require authentication. Okay. Now, say as well, when you kind of talk about interoperability, because I think it's important to do so. Again, there's nothing in the Colorado rules that say you can't use your California process, but I do think it's kind of worth thinking through whether that makes sense, because the California process is so prescriptive, right, with the 2 or 3 data elements and the declaration. I actually kind of wonder whether this obligation to sign a declaration in California would pass muster in Colorado, right? I mean, like requiring people to sign something as opposed to just requiring them to use commercially reasonable methods to authenticate. And so you might be thinking like, well, all right, Dave, what are commercially reasonable methods and factors? Well, the rules answer that question, at least in some respects. Can't charge a fee is one of the things that might be sort of intuitive to you. And then you're supposed to be looking at basically this totality of the circumstances, right? So like what's the right that's exercised? And again, that concept, what they're trying to do there in my mind is they're looking at this idea of authenticating opt-out rights, and they're saying like, well, listen, right? Like the level of authentication that you will need to have somebody access their personal data from you is going to be a lot different than the level of authentication, maybe a lot different than the level of authentication to have somebody opt out of the sale or targeted advertising, right? So I think that's what they're getting at with the data right exercised box on the top. And it just kind of makes sense. It flows from there, right? The type and sensitivity and value and volume of data, that makes sense as well. Hey, if all I have is your email address and your name, right? I shouldn't be asking for, additional information. I shouldn't be asking for your social security number to verify you. And then things like, possible harm, and then also the cost of authentication. So I think these factors make a lot of sense. I think Colorado did a good job of kind of laying this out in a way in which makes intuitive sense to a lot of us. Okay, so let me go now, pivot to the opt-out rights and talk about the methods there. 2 boxes, right? And this is a creature of the statute and the way the statute is set up. So you have the right to opt out. There's 3 opt-out rights: sales, target advertising, and profiling, right? Under the statute, it tells you that for sales and targeted advertising, you've got to provide this link, clear, accessible link, right? And what the rules kind of backfill in here is, providing this link in a clear method, reasonably accessible location outside the privacy notice. And, I'll have it in the next slide talks a little bit more about the links, so I won't get too much into it. The profiling one, though, I think is kind of interesting, which here, again, statutorily, it's not put together with the sales and targeted advertising opt-out. And here what they're telling you in the rules is if you're going to engage in this type of profiling that's covered by the statute, then you've got to provide a method at or before the time the profiling occurs. So it makes intuitive sense, right? If you're going to be subject to profiling, we should probably give you the right to opt out before you engage in the profiling. But just understand it's not buttoned up with the other 2 opt-out rights. So if you use a link, the rules backfill in about what this link would do and what this link would look like. And these 3 factors here, you're going to comply with rule 4.02b. I'm imagining you guys don't have that committed to memory. So, just to kind of tease out a few of what those are, you have to be able to submit a request at any time. It has to be easy to execute. I read that requirement of submit a request at any time is, we're going to have a link in your website footer. Right? And we're all kind of used to that, right? I think that ship has sailed, especially with, do not sell or share, or your privacy choices plus the icon in California. I'm going to talk about that in a second. But point being is, yes, that's your link. Surprise, surprise. And then number 2, again, feels very familiar with California. Take the consumer directly to the opt-out method, right? And then number 3, and this is really, I'm going to tease this out in the next slide because I think it'll be helpful to you. But this idea of like providing a clear understanding of the purpose, right? Like what does that link actually have to say? And the rules give examples. The rules don't say exactly what is specifically required, but I would think we would all use the examples they give. I mean, I always tell people I'm a simple man. If they tell me like, I've got 3 choices, I'm going to choose one of those 3 rather than coming up with my own, right? And so here you can do things like Colorado opt-out rights, personal data use opt-out, your privacy choices, your Colorado privacy choices. And I'm sort of like, burying the lead there, which is this choice of using your privacy choices, which was added in, I can't remember if it was the last round of edits or the second to last round of edits, is extremely helpful to all of us, right? And so on this slide, I've got on the top, I've got the Colorado rule that talks about the link, just copied and pasted it. On the bottom, I've got the California red line from the regulations that just got blessed by the OAL, right? And I have done the hard work of highlighting where these line up here, which is, both of them allow you to use the phrase your privacy choices. Now in California, it is the alternative opt-out link. So there, FYI, dig in there, dig in on the comments about when you can use the alternative opt-out link. There are important aspects in the comments that talk about, whether you could use it even if you're not processing sensitive PI. I encourage you to dig into the comments if you haven't, or if you need that answered for you, we can always flip some information to you. But the California Privacy Protection Agency spoke to this issue more specifically in the response to the final statement of reasons appendices. Anyway, so point being is, if you're looking for a single link to get across the finish line here, look hard at whether you can use the your privacy choices language to check the box on Colorado and California. Now, again, that icon down there at the bottom with the checkbox and the Xbox, you're going to have to use that for California purposes, but there's nothing in Colorado that says that you can't have that icon there as well. And I think, listen, let's just be honest, right? I mean, the same language lines up for a reason, right? I mean, the offices presumably are talking to one another and trying to make it easier on businesses so they can have interoperability with respect to what the links would need to say. Now, the back end of what happens when you click on that link, that's a different story. But here's the comparison. You're probably all yelling, Dave, move on. We've heard enough on this topic. So I will, in fact, move on to the other rights. Okay, so right of access. It's I wish I could tell you there was something unique here with respect to Colorado. It feels a lot similar to California, specific pieces. I will say in the rules, it does say that specific pieces of personal data, they include final profiling decisions, inferences, derivative data, marketing profiles, and other data created by the controller, which is linked or reasonably linkable to an identified or identifiable individual. That is spelled out in the rules, obviously. I was reading that, not committed to memory, but I think that's worth taking a look at is whether or not that's part of your business structure that you would have that type of information. The format, some interesting aspects here on the format, right? I mean, they actually use the phrase you can't use incomprehensible internal codes. That's you come across that when you're reading, you think you kind of chuckle to yourself, right, about what it is that companies must be out there producing to people and that type of stuff. And they do have, and I think this is important, right, to really tease out. They adopted, just like California did in their regulations, Colorado adopted in their regulations this prohibition. You cannot produce certain information to people in response to an access request, right? You cannot produce somebody's social security number. You cannot produce somebody's biometric information. It's basically what's covered by the breach notification statute, right? And this makes sense. It always has made sense, right? And California adopted it first, and Colorado backfilled. The concept is basically like, if you're Dave Stouse and you're making an access request to an entity that's subject to the CPA, and I ask for my social security number, like I know what my social security number is, right? What is the benefit to me of receiving a social security number that I know what it is? And the harm, meanwhile, for the business is, listen, if they didn't get the authentication right and it's a hacker, right, they just gave the social security number to the hacker. I think what they recognize here, and I think this is really good for business, is to say, like, we just got to be reasonable about this. Now, what I will say is Connecticut, Virginia, Indiana, Iowa, right, don't have, actually, I think Iowa actually has this now that I think of it, right? But I think Indiana, or maybe it's Indiana that has it. One of the I's that just passed has this, but you have to look at the individual state statute to see whether it has this or not. But I do think this is one of those areas where hopefully we get, more amendments into these statutes, because this really makes a lot of sense as Colorado recognized. Okay. Right to correction. So not in every state statute, just got backfilled in with the CPRA. Colorado has the right to correction. So what's the process for that, right? I mean, I go to a guy and say, you've got my name spelled wrong. And he says, no, I disagree. I think your name is not spelled wrong. And then we get into a war over what that is. Like, how do I prove that my name is in fact spelled wrong? So first, the process, like if the controller agrees that your information is inaccurate, then they've got to correct it in their existing systems. But you can wait on the archive and the backup systems until a later date. If they're restored, their next access or use, similar to what California does. But this was a change. This was a pro-business change that was made as part of the final rules. As it wasn't the same as was originally drafted. And it makes a lot of sense, right? That your backup tapes are supposed to be backup tapes. They're not supposed to change. You're not supposed to go in there and mess around with them. And so, good recognition here from the AG's office about that. You could direct people to their account settings, right? Like, hey, if you want to go make a change to your profile, just go into your profile and make that change. You don't need me to make that change for you. So there's certain circumstances where you can do that. It's relevant to you. Dig into the rules. And the question ends up being, like I said before, like, how would you prove it? The controller can require individuals to provide documentation, and then try to prove it up. And then if the controller, you can decide if it makes sense that it's not accurate. You can decide that it's more likely than not that the information that you have is in fact accurate and keep it that way. And this whole thing as well, it's kind of worth pointing out that if you were looking at the draft rules, this got a lot more business friendly from the draft rules to the final rules. So certainly worth something like digging in if you're kind of mapping your original procedure to the draft rules. This got a lot better for you. If you deny a request, for correction, based on the fact that you think that more likely than not your information is accurate, you've got to tell them, obviously, that you're denying the request. Describe in the documentation, anything you have in support of your decision, the reason for why you made the decision, and the reason why the information that was provided by the consumer was not sufficient to enable you to correct the information. Okay, right to deletion. Again, familiar concept here. Won't spend too much time on it. Delete it, notify your processors, and a backup system as well. What I will say, I think the big thing that the rules do here that you won't find in the statute, but you'll find in the rules, is there's been this this push after Virginia was passed. Remember, so Virginia was passed, the VCDPA, and then we had a legislative session in the middle, and there was amendments to it, right, last year. And one of the amendments that got put in, I just kind of refer to as the data broker amendment, right? So basically, those are entities that do not collect information directly from consumers, right? And so the concept with those entities is they're constantly ingesting data from different sources, like the LexisNexuses of the world are constantly ingesting data, right? So if they delete it, then they're not going to be able to track that they were supposed to delete it, right? So it's like a point in time type of thing, because they would delete it, then ingest it, delete it, then ingest it, those types of things. So they grafted on in VCDPA what I call like the data broker exemption, which says that you can retain, you do one of two things. You can retain a record of the deletion request and the minimum amount necessary for ensuring that the consumer remains deleted, or you can opt the consumer out of processing for any purposes except those permitted under the statute. Colorado, point being of all this, is Colorado added that on, right? In the rules, they added what we call like the data broker exemption on. It exists in Connecticut as well, and I think we see this pretty typically existing in all these state statutes that are coming about. Again, if you refuse to delete a request, you've got to tell people that you're refusing and point to any exemption that's in place, another basis for denial. Okay, universal opt-out mechanisms. This tends to be a fun topic, at least in my mind. Here's what I'm gonna do though. Like the rules spend a lot of time going over universal opt-out mechanisms, right? The technical specifications, consent, all those aspects to it, right? And so what I try to do is like tell you what it is if you're a controller, what is it that you actually need to know with respect to this to comply, right? So conceptually, if you're not familiar with universal opt-out mechanisms, it allows consumers to make one choice, right? A browser or a browser extension that sends a signal to the site that says I don't want to be tracked, right? That's very high level, I know, but that's just basically what it does. As opposed to going on to like a website footer link and clicking every time you go to a website and opting out, this would allow you to make one decision as opposed to multiple ones, right? Now, what the AG's office has to do though, is they have to publish a public list of universal opt-out mechanisms that they have recognized. They're gonna have to do that by January 1st, 2024. Now, the statute goes into effect July 1st, 2023, in 3 months from now, 2.5. That's a little bit sooner than I was thinking in my head, but in 2.5 months, Colorado goes into effect. And then a year later is when you have to recognize universal opt-out mechanisms. It's a delayed implementation date. So January of next year, you can wake up on New Year's Day and you can look to see what universal opt-out mechanisms have been recognized by the AG's office. Another really good thing that the AG's office did is they said, hey, when we put it up on the list, you're gonna have 6 months to comply, right? This is not gonna be California where the AG's office tweets out that they're you need to recognize the global privacy control signal, updates FAQs, and then start sending out enforcement letters. You're gonna have lead time here. Really good idea here, right? Okay. And then the bottom one too, the processing of the request, you've got to treat it as a valid opt-out request for the browser and if known for the consumer. If you've been digging in on California, there's all of this sort of concept of like, well, if you know the consumer, you've got to roll that up to their profile. Those types of things are really difficult conceptually to try to figure out. That is not dug into in Colorado, whether you do the same thing for Colorado, but dig in on that issue and look at the language. There's certainly not all the examples that you see with the California regulations. Okay, just some more context on the universal opt-out mechanisms. I'm going to give you how it works with cookie banners with 2 slides. You can tell people that you recognize the opt-out preference signal. You can say on your website, opt-out preference signal honored. I know some of the tech vendors now are doing that with the cookie consent banners. That's permissible, not mandatory, but permissible. And then, you can allow people to, so say somebody shows up on your website with a universal opt-out mechanism firing, you can use consent to get around that. Like, hey, no, we really would like, notwithstanding your choice to use this universal opt-out mechanism, we really want to target advertise to you, right? You can do that. You can obtain somebody's consent to do that, but it has to comply with the rules. And we'll talk about consent in a little bit. What I think, though, is useful for you guys, because I know when I came across this, I actually did a screenshot on a Sunday morning, and I sent it to TK and Shelby and said, hey, look at this, right? Look at this language here. This is really helpful. Probably for them, they were saying, like, Dave, leave me alone on a Sunday morning. But I felt like this is a big deal for you guys to kind of tease out. So basically what this gets into is somebody shows up on a website firing the universal opt-out mechanism, right? And here it's a fashion retailer's website, right? And the fashion retailer wants to try to get consent to target advertise to that individual, right? And it says in the second to last sentence there, the fashion retailer's website displays a pop-up banner seeking consent to share the consumer's personal data for target advertising. And he says it's not valid. It's not valid because the request is made through a pop-up banner that degrades or obstructs the consumer's experience on the controller's web page or application, right? This has significant implications for how you use cookie banners in Colorado moving forward, right? FYI, be aware of it. Now, they provide a different example, right, which is basically the same thing, but then they say, well, on that web page, that fashion retailer's web page, they display a message at the top that says, you have opted out of targeted advertising and opted into data use, right? And they say as long as that complies with all of the other consent requirements, we'll talk about in a little bit, that would be valid, right? But this is like FYI, you're going to want to take a look at this, talk about it, talk it through with the way that you're approaching your compliance process in other states as well. Okay, privacy notices. When we last met on privacy notices, we were talking about how Colorado had really gone afar with processing purposes here. The good news is they pulled back on the processing purposes, for each processing purpose requirement, right? But we're going to go through it because I think there's still a lot here that we kind of need to think through. Excuse me. Okay, so starting at the beginning, though, they have these general privacy notice requirements. So understandable, accessible, be available in languages in which the controller conducts business, and readable on devices, right? Everybody's on their cell phones now, right? And you got to be able to read it on there. I think that, probably if you're dealing with clients or you are a client, you're thinking of things like PDFs and how those represent to be, and, all those types of things. I do think the target audiences, the one on the top, the understandable to target audiences, is really kind of interesting as well. And that really we're wrestling with those issues like with children's bills right now, like the AADC in California. But you have to think about who your website's targeted to, right? And understandable to target audiences as far as they go on that one. But I think that's exactly what they're getting after. Okay. Again, good news. It doesn't have to be Colorado specific. I know we're talking a lot with clients about how we'll structure privacy policies with respect to this, but there's nothing in this that says you have to do a Colorado only privacy policy. So good news there. You can think through about how you can blend them together. Has to be clear. I would hope so. We try our best, right? Can't always say that we knock it out of the ballpark, but we certainly don't try to write unclear privacy notices. Accessible, specific. I think these are concepts you guys have probably been wrestling with for a long time. We'll kind of get into a few other things in this as well. Okay, so I wanted to tease this one out. So if you look at the rule, it has privacy notice content. I want to try to connect a couple dots here before we dig into that. So what it tells you here, and again, originally the initial draft said for each processing purpose you had to do X, Y, and Z, right? That language of for each processing purpose is gone, right? And I think the recognition there is like, hey, were we going to have another box here where it says like processing purpose and then personal data and all those types of things, right? And people use a lot of boxes with California. And so I think they had a realization of like, this is probably too much, right? And got convinced otherwise. That said, the concept of purpose specification is very, very, very much alive in the Colorado rules, okay? So if you look at the privacy notice content rule itself, it has that language, which I've obviously quoted, linked in a way that gives consumers a meaningful understanding of how each category of their personal data will be used when they provide that personal data to a controller for a specified purpose, right? And this comes up again as well in later, just in requirements on Rule 6.03, where it says the processing purpose described in a level of detail that gives consumers a meaningful understanding of how each category of their personal data is used when processed for that processing purpose. So it's so important they said it twice, right, in the rule. Maybe there's some nuance there, but really getting after it right there is processing purpose really, really matters here, right? And if we look at Rule 6.06, which we will in a minute, it's a big deal for Colorado. They really focus on this processing purpose aspect of telling people exactly why it is you're going to use that data and not using it in like general and abstract terms or broad terms. It allows you to drive any processing purpose through it. So this is important. When you're drafting your privacy notices, processing purpose is still important. I don't want to lose that thread. Okay, as far as contents goes, shocking. You're going to have to tell people the categories of personal data that's processed. I'm sure that just knocked you out of your seat. What's interesting is they actually provide some examples there of the categories of personal data. So it's not like name, address, telephone number. They use language like contact information and information from cookies. So I encourage you to take a look at those examples because I think they're kind of helpful of how the AG's office is thinking about this. Processing purpose, I think I've explained that one enough. And then you have these obligations around selling and targeted advertising information. So whether it's going to be the personal data is going to be provided for a specific purpose, will be sold or used for targeted advertising, and then category level information. So categories of personal data sold or shared, category of third parties to whom it's sold or shared. This is, the word categories there has significance, right? I haven't mentioned what Washington did with the My Health, My Data Act, at least I don't think I have. That's different, right? That is like specific names type stuff, right? Here it's category level information, which is important, right? Now, Oregon's wrestling with this issue right now as well with their draft bill. So just FYI, we're talking category level type data. If you're engaging in profiling decisions, then we're also going to have additional information for profiling. The other kind of contents that you're going to require, list of data rights, sure. And actually, I mean, surprisingly enough, if you actually look at the statutory language in these WPA variants, they never actually say you need to tell people what their rights are. You have to tell them how that effectuate your rights. But they never actually state you have to tell them what their rights are. I think we've all kind of, as privacy attorneys, just written that in, right? Because it just makes sense. But Colorado rules, they fill that in. Requests, sensitive data inferences. We're going to go over that in a second here. And the rest of the stuff just kind of, I think, makes sense, right? Okay. Changes to a privacy notice. So what if you change your privacy notice? When will you have to tell people that you've changed your privacy notice? You have to tell them that there's been a material change. Again, the draft rules talked about substantial and material changes, right? They also said that you had to do that in 15 days. That 15-day requirement is gone. It actually said in the initial rule, it said 15 days. Didn't say like before 15 days, it said 15 days, right? Which is always kind of an interesting drafting thing. And like, again, I mean, it's easy to be on the outside looking in and trying to say these things, but these are incredibly complicated. But they got rid of it is the upshot there, right? The type of changes, though, dig into it. I mean, look at this type of stuff, right? It's material changes here where you're going to be providing notice or things like categories of third parties you're sharing data with, methods of requests, processing purposes, categories of personal data, process controllers identities like M&A type stuff. And then the notice contents as well, I don't have it on here, but I backfilled this morning, is you would notify people in a manner by which the controller regularly interacts with consumers. Okay. Other data processing requirements, I'm actually kind of kicking myself for using like the other data processing requirements language here because I actually think that it's like crazy important, this section. First one is purpose specification. I previewed this on the privacy notice slide, and I'm going to backfill here, why I think this is important. In the AG's office, if you read like the comments that went around with the draft rules, like the prefatory comments there, they talked about the fact that like Colorado has this requirement, this purpose specification requirement that doesn't find itself in every one of the state privacy statutes, right? And here what they're telling you is specifically telling you that you need to specify the express purpose for which the personal data is collected and processed, both in your external disclosures and internal documentation, right? The express purpose, again, has to make it into your privacy notice. So you cannot read the privacy notice content rule, which is the one we just talked about, 6.03, without reading it in conjunction with 6.06, okay? And then you got to tell people in a level of detail that tells them, basically tell them so they can understand it, right? Cut to the chase there, right? And so yeah, in the end, what it comes down to, right, is that you really had to be thoughtful about the processing purposes and your explanation for the processing purposes here in your disclosures. What they also tell you as well in 6.06 is you can't describe your processing purposes so broadly that it kind of lacks any basis, right? I know that, and you can't future-proof it either, right? So I know a lot of times clients will say things like, well, like, what if we do this in the future, right? Can't we just say it now, right? We'll just write it in, right? That way we'll allow us to do it in the future. The AG's office in the rule said, no, you can't do that. You can't just put a bunch of like random purposes in there because one day you may decide to use it for those types of purposes. If you then go to a new purpose, right? So say like you're using the data on your privacy notice for this express purpose and use it for another purpose, then you've got to obtain consent. And that really goes into the next rule, which is 6.08 that I want to talk about, which is the secondary uses. Here, I mean, it is what it is, right? So it's your use of the data has to be for the purposes that you said it's going to be, or reasonably necessary compatible with those purposes. And then there's like a list of 7 factors that talk about when it's reasonably necessary and compatible. If it's not, then you need consent. Then you need consent. Go back to the consumer. What I want to say is here, though, and I think there's an important distinction to draw here between California Rule 7002 and Colorado's secondary use and express purposes 1. California, I think, my reading of it is of 7002, really talks about the collection itself. The collection itself, the PI has to be consistent with the expectations of the consumer, right? It's not enough in California, and we talked about this in our last webinar, to just say in a privacy policy, we're going to use your information for X, Y, and Z, right? That's not reasonable from a consumer's point of view that they would actually expect it, right? Colorado doesn't, in my reading, does not go so far as that, but it says, hey, you've got to have an express purpose, and that express purpose has to be narrowed to the actual use of that. And then it also talks about, like, if you have these secondary purposes, and if these secondary purposes go beyond what the consumer thinks is reasonable, then you're not going to get consent, right? So what I think this gets after, right, is there's been a lot of discussion in U.S. privacy law about, like, we don't have an Article 6 equivalent as GDPR. This gets you close. And we could argue about how close it gets you, but, that's what we're driving after. Data minimization, again, Rule 6.07, kind of significant here. I think the things to kind of tease out, that second bullet point under the retention issue, you have to set a specific time limit for erasure or to conduct a periodic review. And that sure sounds like a retention schedule to me. They don't say it, but it sure sounds like that to me. Biometric identifiers as well. We're going to talk about that in a second. You got to review those once a year, your biometric identifiers. That rule became more business friendly, but there's still a review for a year. And then sensitive data, we're going to talk about refreshing consent in a second. But if you no longer have the consent to process sensitive data, then you got to stop and get rid of it. Okay. Loyalty programs, kind of going to breeze through these. These are the definitions. The regulations provide definitions of bona fide loyalty program and bona fide loyalty program benefit. Honestly, this is kind of, for me, my reading at least, this is fairly intuitive. So I don't think it's really too much to get into. Like if you go to your grocery store and you get into like the program there, it's a loyalty program. So what do the rules establish the procedures for here, though? They really talk about like this interaction between, okay, so somebody's in your loyalty program and they come in and they say, delete all my data. What do? They're in a loyalty program, right? And they say like, well, I want to opt out of the sale. And you say, well, listen, bro, like that was the entire point of you being in the program was that we could sell your data, right? So what would you do in that situation? And the rules kind of flesh this out. Colorado's regulations did this as well, right? We're actually fleshing out what it would be. What would you do when you get these requests? So take a look at that if it's of relevance to you. And then sensitive data as well. Like if sensitive data is actually necessary to be part of the program, but the consumer refuses to provide the sensitive data, the rules flesh out what you would do in those instances as well. And I know it's not generally applicable to everybody. That's why I'm just kind of giving the high watermarks there, and we can always dig in later. Program disclosures, this, in my mind, goes well beyond California, which is if you have a loyalty program, then you got to disclose things. And you probably have like terms of use for your loyalty program. And so here you're going to have like additional information that you're going to provide people about the personal data that's being used. California has some stuff around financial incentives, as you probably already know. So you're going to have to be looking at what you put out for financial incentives, which is really like the value of the data and those types of things. And Colorado's got its own unique spin on it here with respect to, like categories of third parties that will receive it and all those types of things. Okay. sensitive data, this is really one of the areas too where Colorado goes further, right? So let's talk about it. Now, California has a limit the use of sensitive personal information. Colorado and the other variants have, well, not Utah, not Iowa, but the other, the Indianas, the Connecticut's of the world, the Virginias of the world have the opt-in for consent to process sensitive data, right? We're familiar with that. So where does Colorado go further? Colorado goes further because they create a category called sensitive data inferences, right? Does not exist in the statute, exists as a matter of regulation, of rulemaking. So how did they come up with this, right? Well, basically, and to set the threshold too, I should have said it, is you need consent to process sensitive data and you consent to process sensitive data inferences, right? So the way they came up with this is they use that word revealing there, personal data revealing any type of sensitive data. So personal data revealing at religious beliefs would be one of those. And they said that word revealing includes inferences, right? That is the inference. And so the inference is data, or it could be ordinary data that reveals personal sensitive data elements. Let me give you the examples that they use in the definition of revealing. And I think the first one's probably pretty illustrative, right? Which is, if I have your geolocation data, remember in Colorado, geolocation is not sensitive data, right? It's unique. It's not sensitive data in Colorado. But precise geolocation data, if I have that, and it shows that you're visiting a mosque, then that's going to be sensitive data if it's used to infer religious beliefs, right? So religious beliefs is a data element, sensitive data element. I'm using ordinary data because, at least in Colorado, precise geolocation is not sensitive data. I'm using ordinary personal data to infer a category of sensitive data. It's a sensitive data inference. I need consent to be able to collect it. Except I don't need consent if this applies. I'm collecting it from people over the age of 13. My collection's obvious. I'm going to delete it within 24 hours. And I'm going to have to provide a bunch of information in my privacy notice to do that. I don't sell or transfer it, and then I restrict my processing to an express purpose, right? So anyway, this is all to beg the issue, which is, just don't think about the fact that, like, I have, do I collect religion? Think about the fact that, like, am I using ordinary personal data to infer that I'm collecting religion or any other element of sensitive data? Okay, consent. So let's dig into this one here. So threshold matter, rule 7.02 groups together when you would need consent under the Colorado Privacy Act. Sensitive data, processing children, which is sensitive data. If somebody's opted out of target advertising, sale, or profiling, then you can get consent to have them opt in. We talked about that before. And then these like secondary incompatible purposes, we talked about that as well, right? Like, so you have your express purpose, you go outside that, you can do it as long as you get somebody's consent to do so. So those are the 4 instances in which they talk about it. Now, also want to talk about the fact that July 1st, the statute goes into effect, right? And so people are saying, like, okay, Dave, what happens to the sensitive data that I collected before July 1st? Got to delete it. Well, it depends. And what it depends on, and this is teased out in Rule 7.02b, if you collected that sensitive data and you used the consent mechanisms that we're going to talk about in a second here, all those requirements here, then you're good, right? I mean, if consent yesterday is as good as consent today type of concept, right? If you didn't, then you got a year. You got a year to figure that out. They give you a 1 year time frame. Okay. Oops, sorry, I went too fast. 5 requirements for consent, like raise your hand if you're familiar with GDPR, because that's what this feels like, the DPP guidelines on consent, affirmative action, freely given, and the rest. I'll go into each of these just briefly. Really going to be important if you're collecting sensitive data to kind of dig in here. Clear affirmative action. Some highlights here. Silence is not consent. Pre-tick boxes are not consent, right? So again, we're talking about, certain types of things. This is not like consent for all processing, right? On all personal data. This is consent for things like sensitive data inferences. But like pre-check boxes, if you're trying to, collect information, no, those are gone. And then freely given, conceptually here, right, that middle one I think is kind of significant here, which is, this idea of contract, right? It's not freely given. If it's part of a performance of contract, yes, that's fine. But if it's like outside of the contract and it's not freely given, again, feels very European, these concepts here. And you can't just like put this as part of a broad and general terms of use. In fact, it has to be specific, which is another element here. I think that one on the right is kind of very interesting as well. The sale of sensitive data to one party is not necessary or compatible with the sale to another one. So like sales are going to have to be specific to individual parties. And in fact, when you go into the informed one, and this is what your notice would say, you would have to identify that second column there, bottom one, the name of all third parties receiving sensitive data through a sale to be able to effectuate that. Now, to make it informed, to have all this information here to make it informed, you can put this in your privacy notice. But at the point in time in which people are collecting that information, you're collecting that sensitive data, you've got to provide like a link to the privacy notice. It's similar to the notice of collection with respect to California. It's got to take you to the point in time in your privacy notice that has those specific disclosures, right? You can't just take somebody to the top of your privacy notice. Okay, refreshing consent. So if you haven't interacted with somebody with respect to sensitive data for the past 2 years, then you have to go out and refresh consent, except that if you have the ability, a consumer has the ability to go into your system and opt out, change your preferences, then you don't have to do it. But absent that, you're refreshing consent for sensitive data every 24 months. Okay. UI choice. I mean, this basically comes down to dark patterns, right? UI design, choice architecture. Conceptually, so in the initial draft rules, they talked about basically like everything on your website having to not be a dark pattern, right? They walked that back in the final rules, thanks to, in my mind, some comments offered by FPF and their team, and said, listen, dark patterns is really about consent, right? And so, yes, you can't use dark patterns to obtain consent, but like, we're not talking about your entire website architecture, right? And the AG's office agreed and said, yes, we'll make it just specific to consent. There's 9 principles. I'm not going to go through every single one of these 9 principles. What I will say is I actually read these to be a bit broader than what California did. And also it's important too, because remember, Colorado, this is consent and Colorado requires consent. So like, this is probably going to lead the way as far as dark patterns and how we think about those, at least entities subject to Colorado. I imagine if you're on this webinar, subject to Colorado. So anyway, symmetrical options. So like the I accept versus I do not accept type features, no manipulation. I always think this is funny, right? Like, I want to help endangered species versus I don't care about animals. I guess now I think about it's like funny, haha, right? But it's just kind of like interesting, right? That we all see those types of manipulative language, and they're saying like you can't do that for consent. Again, I don't know that example makes a ton of sense in the rules because like we're talking about sensitive data, right? Those types of things, and this would be like money. But in any event, like you see the point of those. I'm not going to go through all of these things. I think some of them are kind of redundant with what we talked about before, and we're short on time. And I want to get to data protection assessments. This, again, lights and sirens, big deal with respect to what's going on here. When is it required? Statutorily, it is required for a heightened risk of harm. And then it tells you examples, targeted advertising, sale of data, processing sensitive data, and profiling when it's a profiling subject to the statute, and any other substantial injury, right? That's not specified in the statute. The statute has, in one small section, it has, you got to weigh the benefits against the risks, consider using de-identified data, and it's anything that's created or generated after January 1st for Virginia or July 1st for Colorado and Connecticut, right? The Colorado rules, well, they go a lot further here, and what they say is, listen, man, this has to be a genuine and thoughtful analysis. There are over 2 pages of requirements. There's 13 topics, and there's subcategories to a number of those. And when they also talk about the risks, they talk about things that you're going to analyze like constitutional risk, IP risks, psychological harm is one of them, and mental trauma is one of those as well. We're talking a lot about First Amendment issues with the California Age Appropriate Design Code Act, and you see these types of concepts, and whether they go that far remains to be seen. What I want to tell you, though, is like if you're doing a data protection assessment and you want it to satisfy Colorado, are much more extensive than you may first imagine. I sat there with the statute this morning, with the regulations, and with our like template that we've used for like the ICO, right? The ICO template, and it's a lot more in depth. Okay. The other thing I'll tell you is, generated, right? So that, you need to do a DPA for activities that are created or generated after July 1st. And there's 8 factors to consider with like, I'm sorry, explain it this way. Created or generated after July 1st. And then the new processing activity is generated when the old one is developed in a way that materially changes the risk. And there's 8 factors to consider. I think the problem with this one, though, is like, to figure out if it materially changed the risk, you would have had to do a DPA to begin with to identify the risk, right? So I think you're kind of almost forced to do DPAs for all of your processing activities, even though you would be led to believe otherwise with the statute. How that fleshes out, I don't know. But like, again, I don't know how to manage like day 1 risk versus day 2 risk without actually saying what day 1 risk is. Okay. Profiling, kind of go through this quickly because I'm already at time. There's just not enough time of the day, I suppose. But profiling, you have the right to opt out. I've mentioned that a bunch of times, but it's only like very specific things that you can opt out of. The rules tell you is you have to have transparency. You have to tell people what it is that the profiling is, right? What's the personal data? What's the logic being used here? What is it that you actually would be subject to with respect to the profiling? You've got to make those disclosures in your privacy policy. And then it has these levels of automated processing, right? And so there's 3 levels, right? There's solely automated. The computer does everything. Then there's human reviewed, which is basically like human kind of rubber stamp, right? And there's human involved. And human involved is basically like that human actually has the ability to manage the end profiling decision, right? I disagree. I've only used the computer to get me so far in this whole process, right? But I'm going to make the final decision, those types of things. You have the right to opt out of the top 2. The bottom one, you don't have to provide the right to opt out. But if you don't provide it, then you've got to do a 7-part explanation. And then, just to kind of finish on this one here, data protection assessments. If you're doing profiling, then you add an additional 12 topics into your data protection assessment. So really kind of important to figure out whether you're doing profiling. Okay, I'm a minute over. Apologize for going a minute over, but I always call this the shameless plug portion of my webinars, which is we have a blog. If you're not aware, I encourage you to scan the QR code and to subscribe to the blog if you like this, staying up to date on these types of topics. So having said that, I know we're at time. I very much appreciate you guys joining us here today and sticking around for the extra minute.